Chapter 73 Aboriginal and Treaty Rights. Constitution Act, 1982, Section 35(1). Introduction. Although Aboriginal and treaty rights have been recognized to varying degrees since prior to Confederation, constitutional recognition and affirmation of these rights only began in 1982. The law in this area is new, continually changing, and relatively complex. This chapter will provide a brief overview of S35 of the Constitution Act, 1982. An understanding of the legal issues and procedures surrounding S35 forms only part of the broader issues of Aboriginal and treaty rights. The historical and political context in which Aboriginal and treaty rights arise is equally, if not more, important. Practitioners, therefore, are strongly cautioned to acquire a very firm grasp of all aspects of an Aboriginal and/or treaty rights issue before advising clients or pursuing any legal action. This is particularly important where a practitioner is advising an individual Indigenous client regarding rights that are collective in nature and where success or failure may have a prejudicial impact on the larger Indigenous community. Section 35 provides as follows. 35. 1. The existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. 2. In this Act, Aboriginal peoples of Canada includes the Indian Inuit and Métis peoples of Canada. 3. For greater certainty, in subsection 1 treaty rights includes rights that now exist by way of land claims agreements or may be so acquired. 4. Notwithstanding any other provision of this Act, the Aboriginal and treaty rights referred to in subsection 1 are guaranteed equally to male and female persons. Many substantive and procedural differences arise between rights under the Canadian Charter of Rights and Freedoms, Charter, found within SS 1-34, and those under S35, which is outside of the Charter. Some of the differences are as follows. Rights recognized under S35 are not limited by S1 of the Charter. Specifically, the rights are not subject to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. The rights are not limited to being a shield against government action. They can be used as a sword in establishing Aboriginal and treaty rights, or a defense in defending against limitation of those rights. They are effective against any body, government or private, that limits those rights. Aboriginal and treaty rights are not enforceable under S24 of the Charter, which permits application to any court of competent jurisdiction if any charter right has been infringed or denied and gives the courts very broad remedial jurisdiction. The rights are not capable of being overridden by S33 of the Charter. The notwithstanding clause Aboriginal and treaty rights, and other rights or freedoms pertaining to Indigenous people in Canada, cannot be limited by any provision of the Charter. Section 25 states, 25. The guarantee in this Charter of certain rights and freedoms shall not be construed so as to abrogate or derogate from any Aboriginal, treaty or other rights or freedoms that pertain to the Aboriginal peoples of Canada, including any rights or freedoms that have been recognized by the Royal Proclamation of October 7, 1763, and b. any rights or freedoms that now exist by way of land claims agreements or may be so acquired. 2. What is protected. Subsection 35. 1. Applies to Aboriginal and treaty rights in existence when the Constitution Act, 1982, rights, came into effect. Although it does not revive extinguished rights, rights that were merely regulated remain in existence and are protected by S35. Moreover, an existing Aboriginal right cannot be read so as to incorporate the specific manner in which it was regulated before 1982. The phrase existing Aboriginal rights must be interpreted flexibly so as to permit their logical evolution over time. The Supreme Court of Canada in R.V. Vanderpeet established a two-stage test to identify Aboriginal rights. 1. The precise nature of the activity must be identified. 2. The activity must have been an integral part of the specific distinctive culture of the Aboriginal group prior to contact with Europeans. Stage 2 of the test has subsequently been modified in Dilgamuuk v. British Columbia for Aboriginal title claims, a subset of Aboriginal rights, such that the claimant must establish exclusive use and occupation of the territory at the time of assertion of British sovereignty. It has also been modified for Métis claims of Aboriginal rights. Since Métis are the result of contact between First Nations people and Europeans, the relevant time period was altered in R. v. Pauli to the time when Europeans effectively established political and legal control in a particular area. In R.V. Badger, The Supreme Court of Canada set out principles for the interpretation of treaties and the rights that arise from them. Treaties represent an exchange of solemn promises between the Crown and the various Indian nations. The honor of the Crown is always at stake. The Crown must be assumed to intend to fulfill its promises. No appearance of sharp dealing will be sanctioned. Any ambiguities or doubtful expressions in the wording of the treaty must be resolved in favor of the Indians. Any limitation of rights must be narrowly construed. The onus of establishing strict proof of extinguishment of a treaty or aboriginal right lies upon the Crown. The court also stressed and confirmed earlier court decisions that the context in which treaties are negotiated was important and that oral agreements would be recognized. Thus, the words in the treaty must not be interpreted in their strict technical sense nor subjected to rigid modern rules of construction. Rather, they must be interpreted in the sense that they would naturally have been understood by the Indians at the time of the signing. Moreover, the verbal promises made on behalf of the federal government at the times the treaties were concluded are of great significance in their interpretation. In R. v. Marshall, the Supreme Court of Canada added the following principles for interpreting treaties. First, extrinsic evidence is available to show that a written document does not include all of the terms of the agreement. Second, extrinsic evidence of the historical and cultural context of a treaty may be received even if the treaty document purports to contain all of the terms, even absent any ambiguity on the face of the treaty. Third, where a treaty was concluded orally and afterwards written up by representatives of the Crown, it would be unconscionable for the Crown to ignore the oral terms while relying on the written ones. The Supreme Court of Canada in R. v. Simon also held that treaty rights include rights incidental to the activity covered by the treaty. Thus, in Simon, the treaty right to hunt included the right to possess a hunting rifle and ammunition, and in R. v. Sundown, the treaty right to hunt included the right to erect a hunting cabin in a provincial park. 3. Limits upon rights. While Aboriginal and treaty rights are not subject to a S1 charter test, there are a number of limitations. In R. v. Sparrow, the Supreme Court of Canada held that reference in S35 to existing Aboriginal and treaty rights meant unextinguished, and the onus of proof of extinguishment lies upon the Crown. There must be strict proof of the fact of extinguishment and evidence of a clear and plain intention on the part of the government to extinguish Aboriginal or treaty rights. Moreover, the fact that the rights were in any way regulated does not amount to extinguishment. Thus, in Sparrow, federal regulation of fisheries did nothing to extinguish Aboriginal rights to fish. It is also important to note that, 1. As a result of S91, 24, of the Constitution Act, 1867, which gives Parliament authority over Indians and lands reserved for Indians, only the federal government has the constitutional authority to extinguish Aboriginal and/or treaty rights, and 2. Extinguishment through legislation is no longer possible after 1982. If unable to establish extinguishment, the Crown or other party trying to deny the Aboriginal and/or treaty right must prove the infringement or limitation of the right is justified according to the evolving test set out by the Supreme Court of Canada, beginning in Sparrow. In determining whether regulations under the Federal Fisheries Act violated the Aboriginal rights of a member of the Musqueam First Nation who was fishing for food in a traditional fishery, the Supreme Court of Canada in Sparrow set out a two-stage test for infringement and justification. 1. The individual or group asserting the Aboriginal right has the onus of proving that the legislation or regulation in question constitutes a prima facie infringement. Considerations include a. Whether the limitation is unreasonable, b. Whether the regulation poses undue hardship, and c. Whether the regulation denies the holders of the right their preferred means of exercising that right. 2. If prima facie infringement is established, the Crown bears the burden of justification, which includes two questions. A. Is there a valid legislative objective, for example, conservation or safety? B. If a valid legislative objective exists, is it in keeping with the honor of the Crown and the fiduciary relationship between Aboriginal peoples and the Crown? Considerations would include whether a priority allocation was provided to Aboriginal people, whether there has been minimal infringement, whether fair compensation was provided where appropriate, and whether there has been appropriate consultation. The test of valid legislative objective has been broadened in cases of Aboriginal title to include consideration of competing economic interests and development. In cases of commercial resource use where there are no internal limitations, A priority allocation did not necessarily have to be given to Aboriginal peoples for consultation. The test to determine whether there has been appropriate consultation and fair compensation has been considered by the Supreme Court of Canada in several cases. In Haida Nation v. British Columbia Minister of Forests, and Taku River Tlingit First Nation v. British Columbia Project Assessment Director, the court held that the duty to consult and accommodate is triggered when the Crown has knowledge of an Aboriginal right or title, and that the duty to consult can be enforced prior to the judicial determination of the existence and scope of the Aboriginal or treaty rights in question. The duty to consult also arises at the strategic planning stage and cannot be delayed until any point afterwards. The court stated that the scope and content of the duty to consult depends upon the content of the rights asserted and the circumstances, but that it can include revenue sharing of a resource that is being exploited. The Supreme Court of Canada in Rio Tinto Alcon Inc. v. Carrier-Sakani Tribal Council established 3 conditions that must be met in order for the duty to consult to arise. 1. The Crown has actual or constructive knowledge of a potential Aboriginal claim or right. This threshold is not high. Only a credible claim is required. 2. Crown conduct or decision-making is contemplated. 3. The contemplated conduct has the potential to adversely affect an Aboriginal claim or right. In Mikisew Cree First Nation v. Canada Minister of Canadian Heritage, the Supreme Court of Canada required the federal government to consult with affected First Nations where lands were to be taken up pursuant to a treaty. Also, in Beckman v. Little Salmon Carmacks First Nation, the top court mandated consultation where there was already a signed, modern-day, land claims agreement. The court in Little Salmon Carmacks also clarified that individuals do not have a right to be consulted. The duty is owed to the First Nation or Indigenous community. An individual has no standing to seek judicial review of a government decision because that individual was not personally consulted. The issue of whether the duty to consult extends beyond government bodies to boards and tribunals has been debated for many years. The Supreme Court of Canada in Carrier-Sakani stated that tribunals are governed by legislation and that the legislation may provide sufficient jurisdiction for a tribunal to determine whether consultation should take place, whether the tribunal itself should conduct the consultation, or neither or both. Where a tribunal is given the authority to decide questions of law, there is an implied power to decide constitutional issues, including the issue of consultation. However, where that authority exists and a tribunal finds that consultation is required, the tribunal is not obligated to conduct the consultation itself. In Tsleil-Waututh Nation v. Canada Attorney General, the Federal Court of Appeal held that the duty to consult belongs to Canada but that Canada could rely upon the National Energy Board, in this case, to carry out consultation on its behalf. However, if the National Energy Board was unwilling or unable to adequately consult, the Crown must take further steps to consult. In Clyde River, Hamlet v. Petroleum Geoservices Inc. and Chippewas of the Thames First Nation v. Enbridge Pipelines Inc., the Supreme Court of Canada confirmed previously established principles that the Crown can rely on regulatory processes. See Carrier-Sakani to fulfill the Crown's duty to consult and provided guidance on what practices will be sufficient to meet consultation requirements within the regulatory approval process. In another case involving the Mikisew Cree First Nation, Mikisew Cree First Nation v. Canada Governor-General and Council, the Supreme Court of Canada held that the Crown's duty to consult prior to decisions that could affect Aboriginal or treaty rights does not extend to the development of legislation. In Ktunaxa Nation v. British Columbia Forests, Lands and Natural Resource Operations, the Supreme Court of Canada held that a reviewing judge must not decide constitutional issues in isolation on a standard of correctness and should instead ask whether the decision of the decision-maker about the adequacy of the consultation and accommodation process was, on the whole, reasonable. Following the Supreme Court of Canada decisions in Haida and Mikisew Cree First Nation v. Canada Minister of Canadian Heritage, most jurisdictions implemented policies regarding Crown consultation and accommodation. These policies do not necessarily meet the legal requirements for Indigenous consultation, and there are gaps. However, they may present a starting point for the practitioner in considering potential consultation requirements or rights for a client. Five. Fiduciary duty. The relationship between the Crown and Indigenous peoples is fiduciary in nature. The fiduciary relationship and accompanying fiduciary duties were recognized by the Supreme Court of Canada in Guerin v. the Queen. This relationship is linked with the Honour of the Crown Manitoba Métis Federation Inc. v. Canada Attorney General. The Supreme Court of Canada in Williams Lake Indian Band v. Canada Aboriginal Affairs and Northern Development held that a fiduciary obligation may arise in two ways. First, it may arise from the Crown's discretionary control over a specific or cognizable Aboriginal interest. Because this obligation is specific to the relationship between the Crown and Indigenous peoples, it has been characterized as a sui generis fiduciary obligation. Second, a fiduciary obligation may arise where the general conditions for a private law ad hoc fiduciary relationship are satisfied, that is, where the Crown has undertaken to exercise its discretionary control over a legal or substantial practical interest in the best interests of the alleged beneficiary. The court in Williams Lake further stated that a fiduciary obligation requires that the Crown's discretionary control be exercised in accordance with the standard of conduct to which equity holds a fiduciary, as embodied, for example, in the fiduciary duties of loyalty, good faith, and full disclosure. The Crown fulfills its fiduciary obligation by meeting the prescribed standard of conduct, not by delivering a particular result. Although the Crown must have regard to competing interests, the existence of such interests does not absolve it altogether of its fiduciary duty to reconcile them fairly. 6. Use of S35 and remedies. Judicial consideration of Aboriginal and/or treaty rights most often arises in the context of either criminal or quasi-criminal charges or land use disputes. 6.1 Criminal and quasi-criminal prosecutions. Early cases involving S35 resulted from Aboriginal defences to hunting, fishing, and trapping charges under federal and provincial laws. These defensive cases have grown to include broader areas such as timber harvesting, gaming, gambling, customs duties, and income tax. The remedy in these cases relies upon the supremacy of the Constitution, as found in S52 of the Constitution Act, 1982. 52. 1. The Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. Where a breach of Aboriginal or treaty rights has been successfully made out by the accused, and the Crown has failed to justify the limitation, the charging section of the applicable legislation will be found to have no force or effect against the accused on the charge, and an acquittal will be entered. 6.2 Land use disputes. Indigenous groups and governments may also rely upon Aboriginal rights and, less often, treaty rights to assert claims to land and also to prevent development, sale, or other use inconsistent with the Indigenous interest in subject land. The Supreme Court of Canada in Dilgamuukw first addressed the content of Aboriginal title, an element of Aboriginal rights, covered by S35 of the Constitution Act, 1982. The court stated that Aboriginal title provides exclusive use and occupation of the subject land for a variety of purposes, which need not be aspects of the group's traditional practices and culture. The uses of Aboriginal title land must only be consistent with the group's attachment to the land. For instance, the erection of a parking lot over a ceremonial site would not be a consistent use. Since claims of infringement of Aboriginal and treaty rights related to land use including Aboriginal title, do not generally involve legislation, S52 is not generally of assistance in seeking remedies. Rather, Indigenous applicants usually seek equitable remedies, based upon the breaches of fiduciary duty, which typically coincide with a claim for Aboriginal title. They have included claims for permanent and temporary injunctions restraining development or sale of land, transfer of land back to the Indigenous claimant, compensation for loss of use, sale, or other alienation of land, sharing of royalties received from resource development, consultation and negotiation for transfer of land and/or co-management, and declarations of the existence of Aboriginal title. Chief Justice Lameyer in Dilgamuukw specifically approved of compensation for infringements of Aboriginal title, in keeping with the duty of honour and good faith on the Crown. Fair compensation will ordinarily be required when Aboriginal title is infringed. The amount of compensation payable will vary with the nature of the particular Aboriginal title affected and with the nature and severity of the infringement and the extent to which Aboriginal interests were accommodated. Indigenous claimants, particularly in British Columbia, have had great difficulty in obtaining interim injunctions preventing the commercial development or harvesting of lands where they claim Aboriginal title. This is mainly because they sought interlocutory injunctions against the Crown and developers to stop development pending resolution of the Aboriginal title or rights claim. The court in Haida noted the difficulty that Indigenous claimants have in making out a case for interlocutory injunctions, since the balance of convenience test tips the scales in favor of protecting jobs and government revenues, with the result that Indigenous interests tend to lose outright pending a final determination of the issue, instead of being balanced appropriately against conflicting concerns. Because the court found in Haida and Taka River that the duty to consult and accommodate is triggered prior to the Indigenous claimant obtaining a judicial declaration of the existence of the Aboriginal right in question, a similar strategy of claiming remedies based upon the duty to consult has been more successful. For example, subsequent to Haida, the duty to consult has been used by the Musqueam Indian Band to suspend provincial sale of lands for 2 years and require the province to enter into a meaningful consultation process in order that avenues of accommodation could be explored. In the case of Huiaht First Nation v British Columbia Minister of Forests, the Crown had issued a tree farming licence to a company over lands to which the Huiaht First Nation claimed an Aboriginal right. The court granted the First Nation a declaration that the Crown had an obligation to consult with it in good faith. 7. Procedural issues. As with all proceedings against the Crown, Indigenous claimants must comply with the requirements contained in the Ontario Crown Liability and Proceedings Act, 2019 and the Federal Crown Liability and Proceedings Act, together with relevant limitations statutes. Likewise, if the claimant is seeking a remedy under S52 of the Constitution Act, 1982 in the Superior Court of Justice, the plaintiff or applicant must serve a notice of constitutional question on the Attorney General of Ontario and the Attorney General of Canada Courts of Justice Act, S. 109.